Judge Cannone issued her opinion regarding Karen Reed's motion to dismiss based on double jeopardy this past Friday. And it's been a couple days, so you've all had the opportunity to read the opinion, digest the opinion, tune into some other channels to see what they have to say about this opinion. And I am pretty confident that there is a specific part of this opinion which I think flew over everyone's heads. And the reason why it stuck out to me is because I did a lot of research into this area of the law, into double jeopardy, specifically when it relates to Massachusetts law, as I've done a number of different videos on it. You can go check them out and see the exact basis and all of the case law that we explore and explain regarding double jeopardy. So it stuck out to me. There was something about this opinion, a specific area in this opinion, which stuck out to me as odd, that Judge Cannone was relying on a specific case saying a certain proposition, a certain conclusion. And therefore, I had to do some more research about it. And what I discovered, I think, was very interesting. And that's what I'm going to be sharing with you today. Of course, I'm also going to be sharing with you some of my other general issues that I have with her analysis in her opinion. I have a number of different issues, and we're going to be discussing the good, the bad, the ugly, like we always do. And ultimately, at the end of the video, I'm going to tell you whether I feel this was the right decision to deny this motion or not. So without any further ado, let's kind of first set the stage, understand the different arguments, and then we'll take the opinion step by step to really understand the opinion, understand her analysis, and understand what possible some of the questions we can have or some of the issues we can have with her analysis. So let's remember, double jeopardy attaches in one of two ways. The first way is pretty simple. If a defendant is acquitted of a specific crime, well, then you can't charge them again with that crime. Pretty simple. So how do you obtain an acquittal? Well, most of the time you obtain an acquittal by the jury coming back from the deliberation room and saying, we find the defendant not guilty. And if they find the defendant not guilty of charge 1, charge 2, charge 3, whatever charges they found them not guilty, the government can no longer prosecute them for that crime. That is a pretty simple one. But another way to where double jeopardy will attach is if a mistrial was declared and it was inappropriate to declare that mistrial. And that's where it gets a little more complicated. We're going to be jumping into both, of course. But let's just first take the first way to achieve or for double jeopardy to attach. So if there's an acquittal, now the general way that there's an acquittal, like we said, is if the jury comes out after deliberations and says we find the defendant not guilty. Well, here the defendant is arguing, Karen Reed's legal team, they're arguing that even though the jury didn't, after the deliberations, come out into open court and say that we found Karen Reed, the defendant, not guilty of charge 1 and charge 3, but now they are telling us that. Now the jury all agrees. We all agree that this was really what our verdict was. So let's not elevate form over substance. If the substance of their verdict is an acquittal for charge 1 and charge 3, well then double jeopardy should attach. So this argument, like I explained to you many times, if you've been watching this channel, is not a great argument. It's just not. The reason is that from all the case law in Massachusetts, it's pretty clear that a verdict has to be declared in open court in front of all the jury. That's when a verdict has to be declared. It can't be declared weeks or months later. It's not the way this works. There's no case law that says that you could. Now, you'll argue, well, and this is what the defense argues, well, let's bring the jury back. We'll bring the jury back, and they'll now declare their verdict in open court in front of everybody. So what's the big deal? So there was a few month break. Who cares? Let's bring them all back. They'll all agree what their verdict was on charge 1 and charge 3. They were only hung on charge 2. Double jeopardy will attach. Well, the problem with that proposition is that if you want the judge to do something, you've got to find some authority that backs you up, that backs that position up. So you got to tell the judge, look, this case specifically says that you can call the jury back and do what I'm asking. Well, is there any case in Massachusetts jurisprudence which says that you can do this? Well, the only case that they were able to find, the defense were able to find, was a case where there was racial bias injected into the jury deliberations. So that was something when the court stressed that that was something so important, so integral to due process that it's not fair. You need an impartial jury. And if it's clear what's coming out after, the information that's coming out after, that there was some racial bias that was what led to this verdict, then that will be significant enough to bring the jury back. Absent that, there's no case law in Massachusetts or rule at all that says that you can bring the jury back a few weeks afterwards and say, oh, what really was your verdict on charge 1 and charge 3? There's just no case like that. So Judge Cannone quite simply said, there's just no case law. There's no way that we're going to find, number one, that Karen Reed was acquitted actually of charge 1 and charge 3, and we're not going to bring the jury back. So that was pretty simple analysis. She cited all the case law, the correct case law. That wasn't rocket science. I told you already months ago, weeks ago, that this argument is going nowhere in a hurry. And in fact, it isn't going nowhere in a hurry. So let's get to the more important, the more interesting argument about the fact that the mistrial was declared, and it was inappropriate for the mistrial to be declared. It was declared in the wrong way. And this is where we have a number of different prongs that we have to evaluate. The first prong, which we've already spoken about, but the first prong is, did the defense, or the first question we can ask, did the defense request a mistrial? If the defense requested a mistrial, there's nothing to talk about. The mistrial was appropriate. Defense cannot argue now that it's double jeopardy. Well, it's clear that there was no request for a mistrial. So let's move on. The next thing is, was there consent to a mistrial? Was there consent? If the defense consented to the declaration of a mistrial, then that would also mean that you can't come back and argue that there's double jeopardy. You consented, the mistrial was consented to, it's appropriate, and therefore there's no double jeopardy. So here was the big problem for the defense. Why was it a big problem? It was a big problem because the defense did not object. When Judge Cannone declared a mistrial, the defense attorneys who were sitting at the table did not object at the time. They did not object later when they were discussing the next date when the jury was still there. They had all this time to object, and they did not object. So, well, what does the case law say about objecting? Do you have to object? If you do not object, does that mean that you consented? And the case law here is clear that the defense has to object. The only case, which we spoke about already a bunch of other videos, the only case where the defense was not required to object was when it came out of nowhere. When the judge just walked into the courtroom, declared a mistrial, everyone's there scratching their heads, what just happened? And the defense didn't have the opportunity, didn't object. So then it was not held to be with consent. But in any other case where there is a reasonable anticipation that there is going to be a mistrial declared and you did not object, well, then in that case, that's going to be considered consent. The case law is pretty clear. Now, that is the analysis that Judge Cannone should have done. But instead, she did something a little bit different, which we're going to jump into now. And I'm going to tell you what my issues with her analysis about this prong is specifically. All right, so she does state the cases about having the opportunity to object, and therefore the fact that they didn't is dispositive. And then she talks about this idea that Yannetti requested a Tui Rodriguez charge. And we've spoken about this. Does requesting a Tui Rodriguez charge mean that you are consenting to a mistrial? Just by requesting a Tui Rodriguez charge. And we've explained pretty clearly that no. Requesting a Tui Rodriguez charge is not consenting to a mistrial. What it means is you want them to be read the Tui Rodriguez charge. And you want the jury to be more open-minded, to discuss it, come out with a verdict. You're basically asking for a verdict. You're not asking for a mistrial. That's essentially what the Tui Rodriguez charge is. So, but Judge Cannone still goes with some analysis with this, and we're going to break it down the following. So she cites Massachusetts general laws, and it says, provides the following. If a jury, after due and thorough deliberation, returns to court without having agreed on a verdict, the court may state anew the evidence or any part of the evidence, explain to them anew the law applicable to the case, and send them out for further deliberation. But if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent, unless they ask from the court some further explanation of the law. So what does this Massachusetts general law stand for? What it stands for is the following. If the jury first went through due and thorough deliberation. So the first question that you have to ask yourself is, did the jury have due and thorough deliberations? If they did, then they can only be sent out once. You only have one more chance to send them out after they went through doing thorough deliberations. You can send them out one more time. And then after that, if they come back a second time and say we're still hung, you cannot send them back for more deliberations without their own consent. Of course, if they say, yes, we want to deliberate further, then fine. But otherwise, you can't send them out again. All right. So in their note, this is Judge Cannone talking. In their note to the court, the jury specifically stated to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs, making it clear that they would not consent to continuing their deliberations. So Judge Cannone is saying, well, it's very clear from the note that they have no interest in consenting to further deliberations. They said very clearly that to continue to deliberate would be futile. So they're very clearly saying we do not want to continue deliberating. So in terms of whether they're consenting, they're not consenting. And now listen to what she says here. Attorney Yannetti twice argued for the court to give the Tui Rodriguez instruction. As you remember, the first time they sent out the note, right away, Yannetti said we should read them the Tui Rodriguez charge, and the judge did not agree. Said, no, I don't believe that it's been due and thorough deliberations yet, and therefore we're going to send them back. Now, that's not considered one time because it's only after they've gone through due and thorough deliberations, then you only can send them back one more time. But if you find, like in this case, that they did not go through due and thorough deliberations yet, then you can send them back a whole bunch of times. And that's exactly what the judge did. But this is what Judge Cannone is saying. Again, the attorney Yannetti twice argued for the court to give the Tui Rodriguez instruction, the final step before the court would declare a mistrial. As we know, that's the final step. You read them the Tui Rodriguez charge, and they saying that we're hung. There is no more sending them back unless they consent. And in this case, they did not consent. Okay, now listen to what they say here. Counsel's request for Tui. Okay, so then she cites Ray versus Commonwealth. Okay, now listen to what she's trying to do here, because this is also, it's very clever, but it's not exactly really what happened in this case. Listen to what she says. She cites Ray versus Commonwealth, and this is what she says the case stands for. Counsel's request for Tui Rodriguez instruction permitted the inference that both parties were provided an opportunity to be heard on possible alternatives to a mistrial. So remember that when you go down the analysis of manifest necessity, which is what's required to be shown if there's no request and there's no consent by the defense, well, manifest necessity would require that the judge consider alternatives to a mistrial. So she is citing Ray versus Commonwealth to say that here, counsel's request for a Tui Rodriguez instruction, the court was permitted the inference that both parties were provided an opportunity to be heard on possible alternatives. But that's not exactly what happened in Ray versus Commonwealth. That's not exactly what happened, that just the defense asked for a Tui Rodriguez charge and the Supreme Court decided, well, that's like the judge considered other alternatives. No, that's not what happened in that case, actually. In Ray versus Commonwealth, and I don't know if other channels picked on this either, but this is not my ultimate point, but I don't know if a lot of channels picked this up either. In Ray versus Commonwealth, what happened there was the judge, after the jury was hung, and they sent out a note saying we're hung, the judge told the attorneys, I'm considering right now declaring a mistrial. That's what she said. That's what the judge said in that case. And the judge in that case said, well, what do you have to say about that, defense and prosecution? And the defense and prosecution both said, well, we don't think you should declare a mistrial yet. We think that you should read them the Tui Rodriguez charge. All right. So ultimately, when this case went up to the Supreme Court, they said, well, there you have the consideration. Is the judge going to order a mistrial? Is the judge going to read the Tui Rodriguez charge? That was considered, that the judge considered other alternatives to a mistrial, because they're having a discussion about the mistrial. Now, in this case, Judge Cannone did not say, I'm thinking about ordering a mistrial. What do you think about that, Yannetti? That's not what she said. She said, we have this letter. What should we do? And there, Yannetti said, well, I think we should read the Tui Rodriguez charge. So there was no discussion at all about the mistrial at that point. In fact, in any juncture where Yannetti was talking about the Tui Rodriguez charge, Judge Cannone was not discussing the alternative or alternatives of declaring a mistrial. That was not part of the discussion. So really, this is a little clever here, but it's not It's not the same thing that would happen in this case. But the Judge Cannone still tries to use this case to show that Yannetti, by asking for the Tui Rodriguez charge, that's kind of like we considered all the alternatives, and it's also she's trying to show that that's really also consent. Specifically, on Friday, June 28th, 2024, after 3 days of deliberations, when the jury sent their first note indicating that they had engaged in an exhaustive review of the evidence and had been unable to reach a unanimous verdict, Attorney Yannetti argued that the jury had engaged in due and thorough deliberations. Was that an impasse and should be given the Tui Rodriguez instruction? The following Monday, when the jury sent a second note after deliberating for approximately 2 hours, stating that consensus was unattainable, Attorney Yannetti again argued that due and thorough deliberations had occurred and described the jury as hopelessly deadlocked. Defense counsel, in arguing twice that due and thorough deliberations had occurred and pushing for the instruction, presumably, listen to what her analysis here, that since Yannetti was pushing for the Tui Rodriguez charge to be read, presumably Yannetti was aware of the legal implications if the jury returned deadlocked again, which was what? The declaration of a mistrial, perhaps. Okay, so what? So what? He's aware of what happens after you read a Tui Rodriguez charge. What does it have to do with consenting to anything? Well, this is what she says. Nevertheless, in a remarkable turnaround, defense counsel now argues that the result they twice advocated for was sudden and unexpected. Okay, now let's take this sentence apart because it's really an important part of her analysis. And it doesn't make much sense to me because that's not what happened. So listen to this again. You have Yannetti arguing twice for a Tui Rodriguez charge. Then she sends the jury back. Now, Yannetti knows that if they come back again deadlocked, we cannot send them back for further deliberations. So he knows what potentially is a possibility if they come back without a verdict, right? That's all he can possibly know. All right. So now she says the following again. Nevertheless, in a remarkable turnaround, what turnaround are you talking about? But this is what she says. In a remarkable turnaround, defense counsel now argues that the result they twice advocated for, what was the result they twice advocated for, please? What was the result? The result was simply reading a Tui Rodriguez charge. They didn't advocate for any other result. They didn't know that Yannetti didn't know that the jury was going to come back after the Tui Rodriguez charge was read to them, that they're going to come back as hung. He didn't know that. He wasn't advocating for any result. The only result that he was advocating for was that the Tui Rodriguez charge should be read to them. That's it. But Judge Cannone is trying to imply that no, since he knows that this is the last opportunity for the jury, and if they send back another note, that means that we're going to have to declare a mistrial. So that means that he was advocating for the result of a mistrial. That doesn't make much sense, does it? But that's what she's saying. And again, their papers in their motion, what they argued was sudden and unexpected was the fact that the Judge Cannone, declared a mistrial. The declaration of a mistrial was sudden and unexpected. Now, you can argue about that in a different way. You can say that they can still reasonably anticipate that it may happen. But to argue that they advocated for a certain result twice, that is not correct. They didn't advocate for any result. The only result that they advocated for was to read the Tui Rodriguez charge. So that is a faulty analysis. It just doesn't make sense. Okay? Again, if you're Judge Cannone, you can say, don't say that it's sudden and unexpected because you should reasonably anticipate that a mistrial may be coming down the line, but don't say that by you asking for a Tui Rodriguez charge twice, that means that you were advocating for a result of a mistrial. That's not what you were doing. All right, so let's move on. Although the court did not specifically ask defense counsel if they had any objection to the declaration of a mistrial, right? That was clear because the judge just called them in and said, I'm declaring a mistrial. Counsel had multiple opportunities to voice an objection if they in fact had one. Now here we're actually getting to a much better argument or analysis by Judge Cannone. They had multiple opportunities to voice an objection while waiting for the jury to enter the courtroom. After the court announced the jury was again at an impasse on the afternoon of July 1st, 2024, defense counsel could have asked to be heard on the issue. That's true. During the subsequent discussion about scheduling a status hearing, right after the court declared a mistrial, counsel had yet another opportunity to inform the court of its dissatisfaction. Absolutely. They could have objected all this time. And this is something that I pointed out in all of my videos in the past. Lastly, counsel could have communicated to the court any objection or request to pull the jurors while the jury was still at the courthouse waiting in the deliberation room after the declaration of the mistrial. Instead, defense counsel said nothing to the court about the mistrial and then proceeded to the courthouse steps where Attorney Jackson declared to the media and onlookers that the Commonwealth failed miserably and will continue to fail with its prosecution of the defendant. It strains credulity to believe that if defense counsel wanted to voice any objection to the court, it would have not been heard. Significantly, and this is something that I also pointed out in some of my videos. Significantly, maybe she's watching. Significantly, defense counsel were no shrinking violets. These are very seasoned attorneys. They know how to make an objection. And in fact, they did object many, many times throughout the trial, as we all know. So these aren't some shrinking violets on their first case who are still trying to find their voice. Neither Attorney Jackson nor Attorney Anetti has ever needed this court to inquire whether counsel had any objection in order to be heard. And the court has never denied defense counsel the opportunity to be heard in open court or at a sidebar. The court reconvened many times at counsel's request. Just days, as we all remember this, just days before the declaration of mistrial, defense counsel asked to address the court while the jury was deliberating to raise an objection about the verdict slip, right? We all remember that. Attorney Jackson was not shy informing the court that he wanted to make his argument and that the court's decision about the verdict slip was not how it should be and it's over our strong objection. Attorney Jackson went so far as to suggest that it was almost like the court is directing a verdict of the subordinate charges by not making changes he wanted. The court finds it hard to believe that when counsel heard that the jury was at an impasse for a third time and a mistrial was inevitable, at perhaps the most crucial point in the trial, counsel would sit silently if they did not consent to a mistrial. So a very strong point by Judge Cannone, which I've been saying all the time in my videos, that here, this is the strongest argument against the defense's position. Now, whether you're a Karen Reed fan or not, this is the objective truth of the case law. If you don't object, that is what the case law says. And there was an opportunity for them to object. And in fact, they had reasonable anticipation, which is what the exact site of the case law is. If the defense attorney has a reasonable anticipation that a mistrial is coming down the road, then they have business objecting at some point. All right. As such, the court does not credit Attorney Jackson's averment that he lacked an opportunity to be heard. Defense counsel's silence, despite ample opportunity to be heard, is deemed consent. All right. So that is the issue with regarding to consent. So her argument or her opinion that the fact that they asked for a Tui Rodriguez charge, that equals consent, that is incorrect. That is not a good analysis. But this other part of her opinion, that the fact that they didn't object means that they consented and they reasonably could have anticipated, that is correct. All right, now let's move on. Even now, here's where it's going to get a little bit more troublesome for Judge Cannone. She's going to feel the heat a little bit here. And the reason for that is that if you just stop the analysis here and say, therefore, finished, you consented to the mistrial, and that's why double jeopardy doesn't attach, the mistrial was appropriate, and you stop the analysis there, stop the opinion at page 15, then you're good. But Judge Cannone has another problem because she wants to really make everything that she did right. And the way that she declared the mistrial does not seem exactly the right way to do it, especially under Massachusetts law. Because as we explained, let's just play the game, assuming that there was no consent. So there's no request, there's no consent. Now you have to go with manifest necessity. Well, the case law in Massachusetts is pretty clear that manifest necessity, if you want to declare above and ignoring the defendant's objection, let's just say, if you still want to declare a mistrial because of manifest necessity, you still have to give counsel opportunity to be heard, and you also have to give careful consideration to alternatives to a mistrial. Now, that was very clearly not done in this case. So Judge Cannone has a problem here because she doesn't look that great. Even though you're right, technically you got out of it because the fact that there's no objection, you really saved yourself. But now you still don't look that great because you didn't follow the whole manifest necessity prong that if this was really a declaration of mistrial. So she wants to make herself kind of look good. And this is where she's going to run into some problems. All right. So let's continue down this analysis. Now, this is what she says. Even assuming arguendo that the defendant here did not consent to the mistrial, the law is clear that a retrial is permissible so long as there was manifest necessity for the mistrial. Right? So, was there manifest necessity or not? Well, one of the classic examples of manifest necessity is if the jury's hung. The trial judge's belief that the jury is unable to reach a verdict has long been considered the classic basis for a proper mistrial. Because the court here had no doubt, based on the jury's notes to the court, that it was unable to reach a unanimous verdict, and the jury represented to the court that continued deliberations would be futile, there was manifest necessity for the mistrial based on the deadlock. As stated above, the foreperson on behalf of the jury in this case sent the court 3 notes, none of which indicated agreement on any of the charges. In the first note, the jury wrote that they had been unable to reach a unanimous verdict. In the second note, they stated that they were deeply divided by fundamental differences in our opinions and state of mind, and that consensus is unattainable. In the third and final note, after they had been given the Tulio-Rodriguez instruction, the jury stated that they continued to be at an impasse. They described themselves as starkly divided on their perspectives on the evidence, explaining, and this is the following what their note says. Some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of the charges beyond a reasonable doubt. Conversely, others find that evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. The charges. The deep division is not due to lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs, right? Everyone's familiar already with that last note. The only reasonable interpretation of these notes, and specifically the final note, again, this is all from Judge Cannone's opinion, was that the jury could not agree on any of the 3 charges, and further deliberations would serve no purpose. Now, there's a footnote here, and this footnote is interesting because this is a point that I actually made in my videos analyzing this topic. So, again, either Judge Cannone is watching, which is good move on her part if she is, or she thought about the same idea that I did. And this is what her footnote says. Given the care that went into writing the notes and how articulately they expressed the jury's disagreement, it strikes this court as odd that there was no inkling of an indication of agreement in the content of the notes. Meaning this is in a very articulate form. They're obviously thinking a lot before they're actually writing these notes. They're extremely articulate. And they're very clear. So you would think that if they have any sort of agreement, they would put that in the note. Or that if the jurors were uncertain, because then you're going to say, well, they didn't know whether they're allowed to even put that in the note. Well, if the jurors were uncertain whether, or that if the jurors were uncertain whether they can return a partial verdict, they would not have asked the court, meaning they would have asked the court. This is a very articulate foreperson. So the fourth person could simply ask, Judge, are we allowed to even give you a partial verdict or not? Ask that question in the note. So that was another point that she made in her opinion. And now, for the defense to now claim that the notes were susceptible to different interpretations, as everybody has heard already, does the charges mean all the charges, or does the charges just mean the charges in count 2? So for the defense to now claim that the notes were susceptible to different interpretations, such that the court should have inquired further, rings hollow, particularly where Attorney Yannetti had twice argued that the jury had engaged in due and thorough deliberations and could not agree. Now, that part doesn't really add up, but it's a decent argument to be made that when they write back that we're hung on the charges, you can reasonably assume that they mean all the charges, even though they didn't write all, but the charges would seem to include everything. All right. Now, this is really where Judge Cannone has a problem. And we're going to get to this next part of the paragraph. And this is why you got to be very careful when you're reading this opinion. And this specifically, which I'm going to talk about, this specifically is what I think you probably haven't heard up until now, and you're probably not going to hear from any other channel. And again, if you do, please let me know in the comments that anybody else has figured this out, because this took a little bit of work. So here we go. The defendant contends that the court failed to carefully consider that as an alternative to a mistrial, it could have simply asked the jury to specify the charges on which it was deadlocked. All right? Right. So this is the problem. The problem is that if we're going to assume, and Judge Cannone doesn't have to do this, but she's still running through the analysis because she still wants to make herself look good, that she actually did the right thing here. If you want to assume that the defense really did not consent, and their failing to object does not equal consent, let's just play it out. That means that you have to find that there's a manifest necessity. Well, if there's manifest necessity, as we've quoted in all these other videos that we did for you, there's two requirements. Number one, counsel has to be heard. Number two, that there has to be careful consideration for the alternatives. That was not done here. So the judge is going to have to find some case that says you don't need to do that. And that's what she tries to do. So here we go. The question, and this is taken from a case of Ray. The question whether a mistrial is appropriate in the circumstances of a given case is not answered by the application of a mechanical formula. So here she's saying, hold on a second. This is Ray, right? This is Commonwealth versus Ray. We actually quoted before, which is weird. The judge, again, we have to get those facts of that case clearly to really understand this. In Ray, the judge said, after the jury sent back a note saying they're not sure what they're going to, they're hung. The judge said, I'm considering ordering a mistrial. And there the defense said, let's read them the Tulio Rodriguez charge instead. And there the court found that that's considered good enough consideration of alternatives to a mistrial, because he did suggest, okay, we're talking about mistrial now. Let's get it all out. Let's air out everything all the alternatives that you think I should do. And the only suggestion that they had was read Tulio Rodriguez. And the judge said, I'm not going to read Tulio Rodriguez. I'm just going to declare a mistrial. And the judge is allowed to do that. Tulio Rodriguez charge is not required. It is a suggestion. You could do it, but you don't have to do it. And that was what the court was clear about. And in analyzing this, the court said the following, that the question whether a mistrial is appropriate in the circumstances of a given case is not answered by an application of a mechanical formula. Meaning there's no formula that we can give the judge and say, follow these steps A, B, C, D, and E. And then if you follow all those steps, then you can declare a mistrial. There's no mechanical formula here. So here, Judge Cannone is using the same argument to say there's no mechanical formula over here that I have to speak to the attorneys and get their suggestions and alternatives. That's the case that she's trying to make her. But really, again, this is not a great argument. Why? Because in Ray, they were actually discussing the topic of a mistrial. And in this case, in Karen Reed's case, they did not discuss the topic of a mistrial at all. But nevertheless, she tries to bring this as some support for what she did. Okay, so again, this is not a great argument. But here's where it gets really interesting. Rather, the court considers several facts, such as the statements in the jury's note concerning their inability to reach an agreement, the time spent in deliberations, and the length and complexity of the trial. And then she cites the following case. And this is the first time I'm seeing this case quoted. So from the defendant's moving papers, from their motion, from the response, from the reply, I never saw this case quoted. Well, which is why it piqued my interest. But listen to what she says this case stands for. It's called Renico versus Lett. And this is a United States Supreme Court case. Listen to what it says. We have never required a trial judge, before declaring a mistrial based on jury deadlock, to force the jury to deliberate for a minimum period of time, to question the jurors individually, to consult with or obtain the consent of either the prosecutor or defense counsel, to issue supplemental jury instruction, or to consider any other means of breaking the impasse. Well, whoa. Wow, what a case. This really makes Judge Cannone look amazing. Because this case says specifically, we have never required a trial judge before declaring a mistrial based on jury deadlock to what? Consult with or obtain the consent of either the prosecutor or the defense counsel, or to consider any other means of breaking the impasse. Wow. Well, that sounds like the judge has complete discretion to do whatever she wants. So this, to me, is problematic. Why? Because I did the research on the Massachusetts cases, the state of Massachusetts cases, and those Supreme Court decisions say very clearly that actually the judge must, number one, give full opportunity for counsel to be heard, and number two, carefully consider alternatives to a mistrial. So that's why it got me wondering. I wonder what this case is really about. Renico versus Lett. So I looked it up. All right. Now, this is what that case is about. And now you're going to see why this is a very clever move by Judge Cannone, but it really is not applicable to this case. What happened in that case is that was actually a Michigan case. It started off, even though it ended up in the United States Supreme Court, it started off as a Michigan case, actually in my state, my home state, and where I practice, Michigan and New Jersey. So, but I'm based in Michigan mostly. So that case there was a murder, and someone was charged with first-degree murder. Now, there is a specific act. It's called AEDPA, which is the Anti-Terrorism and Effective Death Penalty Act of 1996, referred to as AEDPA. All right. Now, what that provision provides is the following. If you have a case and you have some case like this, and it doesn't only apply to terrorism, we're not going to get into the weeds of it, but it applied in this case where you had a person who was charged with first-degree murder. And in that case, there was a question about a mistrial being declared. The judge declared a mistrial, and there was some arguments about double jeopardy. Okay, so it came up to the Court of Appeals in Michigan, eventually made its way to the Michigan Supreme Court. Again, that's still in the state system. And then it got appealed to the Sixth Circuit, which is the federal system. And how can you take a case which is being tried in the state system and appeal it to the federal system? How does that work? Can you do that? Like I've always explained on this channel, there's two different systems. There's the state system and there's the federal system. So how can they remove this case and start arguing in the federal system and appeal it to the Sixth Circuit, which Michigan's included? Well, they could under this act, the Anti-Terrorism and Effective Death Penalty Act of 1996. And what that act says the following. In that act, if you want the federal courts to free your client, it's a habeas corpus. That's what you want. You want that your client who was just convicted in state prison, in the state court, and he's sitting in state prison, you want him to be free. And the way to do that under this is the following. You could ask for a habeas corpus, which is to get him free. You could ask for that in the federal courts if it meets certain requirements. And one of the requirements is the following, and this is under the AEDPA. This is a federal habeas corpus. So even though he's in state and he was tried in state, but the feds can get involved and say he's going free. How? If there's some sort of decision in this case. So in this case, there was a mistrial. And then he was tried again and he was convicted, by the way. So they wanted the first mistrial to be considered not appropriate, and therefore double jeopardy attaches, and therefore he should not have been able to be charged a second time, and therefore he should go free. So if the first decision to declare the mistrial, if that was contrary to or involved an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States, and that's the prong. There's really two different sections under this act, but we're just going to concentrate on that one because that is really what the court was doing in this case. So they were analyzing this. Did the trial court, when this trial court found that this mistrial should be declared, was it contrary? Was it an unreasonable, contrary to the application of clearly established federal law? Okay, so even though this is a little bit nuanced, But you have to understand that this has nothing to do with what's happening in Karen Reed's case. And this quote that that Judge Cannone is quoting from this case has nothing to do with the situation. So this is the United States Supreme Court analyzing, is what the Michigan trial court, is what they did contrary to clearly established federal law. If you find that what this trial court judge did in Michigan is contrary to clearly established federal law, then we can send this guy free. So therefore, the entire analysis, and this is clearly established federal law as determined by the Supreme Court of the United States. So it's not just clearly established law in the Sixth Circuit, it's the United States' understanding. And of course, maybe it may not surprise you at this point, but there is no clearly established law by that federal law that has been determined by the Supreme Court of the United States that says that you need to have full opportunity to be heard or careful consideration of alternatives. That's not a Supreme Court decision. It's not a United States Supreme Court decision. It's not a federal decision. So therefore, under the AEDPA in Renico versus Lett, this case, this is what they're saying. They're saying that we, meaning we, the United States Supreme Court, have never required, so in federal law, we've never required to do any of this stuff. So therefore, if you want this federal habeas corpus, you're going to lose. Because in federal land, in federal rules, you don't have to follow these different requirements of giving counsel full opportunity to be heard and careful consideration of the alternatives. But in Massachusetts state law, you do. And you're in Massachusetts state law right now. You're in a state court right now. You're not asking for a federal habeas corpus. You're in state court. And therefore, the judge has to follow state law. Now, if the defense is asking for habeas corpus, a federal habeas corpus, okay, you can start talking about Renico versus Lett. But she is injecting this statement from Renico versus Lett, which has to do with habeas corpus, which has to do with federal law under the United States Supreme Court, which has nothing to do with what's going on in Massachusetts state law. And Massachusetts state law is clear that you need to have two things: full opportunity for counsel to be heard, and number two, careful consideration of the alternatives. And that was not done. So as much as she's trying to use Ray, which we explained already, is nothing to do with this case, and Renico versus Lett, that has nothing to do with this case either. And that's the point. This is the point, Renico versus Lett, that I think you probably didn't get from anywhere else. Why this is absolutely nothing to do with this case, and therefore she was required to follow Massachusetts state law. And then she actually does quote what I think is the most important case, which helps her position. And that is the Fuentes case, as we've spoken about. And here she goes. We're here. The jury had been deliberating 5 days, had returned to the court 3 times saying they could not agree, had been given the Tui Rodriguez instruction, and returned hours later with a note plainly indicating that they could not agree to the elements of the charges and that to continue to deliberate would be futile. Asking the jury on which charges they were deadlocked was not necessary to determine that there was manifest necessity for a mistrial. And what do they quote? She quotes Fuentes versus Commonwealth. And as we've spoken about, Fuentes versus Commonwealth was almost the exact same situation as the Karen Reed case, almost exactly the same. I told you one way how you can distinguish it, but other than that, it's generally the same exact thing. There was no careful consideration. There was no full opportunity for counsel to be heard in Fuentes, and nevertheless, Fuentes held the Supreme Court of Massachusetts. This is the state case. So forget about what we spoke about Renico versus Lett. This is the state Supreme Court in Fuentes. They said that there was still considered manifest necessity, and therefore there's nothing wrong with how the judge issued or declared the mistrial in that case. Now, as we've spoken about, it is very clear that Fuentes contradicts a number of other Massachusetts Supreme Court cases. It just does. And the question really is going to be, because again, those other cases from the Supreme Court in Massachusetts are clear that you do need to give careful consideration to alternatives. You need to give counsel opportunity to be heard. Fuentes definitely says that you don't need to. Okay, so that's a big problem. It's a big contradiction, and therefore if this gets up to the Supreme Court in Massachusetts, the right thing that they should do is overrule Fuentes. But we'll see if it ever gets there. But as it stands now, Fuentes is definitely going to help her, and that's why she quotes it in her opinion. Moreover, listen to this. The defendant's argument ignores the fact that one of the 3 charges had lesser included offenses. So what was the alternative? Here she's explaining the different alternatives. What were the alternatives that the defense wanted the court to consider? Well, one of the alternatives was, very simply, ask the jury if they have any of the verdicts on any of the charges. Are they hung on all the charges, or are they just hung on 1 or 2 of the charges? That's what they should have done. So listen to what Judge Cannone says here. Well, here's the problem. This is what Judge Cannone is arguing in her opinion. The problem is that, as we know, count 2 had a number of lesser included. And we know that there's case law that you can't ask a jury for separate verdicts if there's a lesser included. So if you have one charge and you have a whole bunch of different lesser included, you can't ask the jury for separate verdicts on that lesser included. So now Judge Cannone says, well, I can't ask them for separate verdicts because the second charge has lesser included. So now she's creating basically new law right now, because she's creating new law where up until now, the case law in Massachusetts was that if a charge, one charge, again, if this person is being charged with one charge and there's lesser included, you can't ask for separate verdicts. That's too coercive. You can't ask for it. If a person is charged with, let's say, 3 different charges, then you definitely could ask. You have the opportunity. You are able to under the rules of criminal procedure in Massachusetts. But what happens when you have 3 charges, 2 of them do not have lesser included, and 1 of them does? Well, according to Judge Cannone, you can't ask for separate verdicts on any of the charges. Now, the reason for that, the reason why you're not allowed to ask for separate verdicts on when you have one charge with lesser included is because it seems coercive for the jury to come to some sort of decision on some of the lesser included. You're kind of coercing them to come to some of the decisions. Now, again, whether you agree with the analysis or not, I don't care. This is what the case law says in Massachusetts with regard to lesser included. If a person is just charged, let's just take the case, a person is just charged with one charge which has lesser included in it, you're not allowed to ask the jury for separate verdicts because it's too coercive. But if you have 3 different charges, you're not asking them to give you a verdict on charge 2, on the lesser included in charge 2. You just want to know, do you have a verdict on charge 1? Do you have a verdict on charge 3? That's not being coercive. But Judge Cannone is saying if there's any of the charge with 55 charges and any of those charges has lesser included, according to Judge Cannone, you can't ask for separate verdicts on any of the charges. It's too coercive. That's what her analysis is. And again, that is not great. It's faulty. Doesn't make that much sense. But that's what she argues for. And then listen to what she says. Therefore, again, moreover, the defendant's argument ignores the fact that one of the 3 charges had lesser included offenses. Therefore, if upon questioning, the jury had indicated to the court that they were not deadlocked on all the charges, the only option would have been for the court to send the jury back for further deliberations. Such actions would be improperly coercive under the circumstances. So she's saying the only way to figure out what the jury is thinking is if you send them back for more deliberations. So I don't understand that, because how is that the only option? Just ask them in open court. We're not asking you to go deliberate more. You guys already deliberated. We just want to know, are you hung on only charge 2, or are you hung on charge 1 and charge 3 also? Just tell us which charges you're hung on. You don't have to deliberate at all. You already deliberated. You're good. Just tell us which charges, charge 1, 2, or 3, that you're hung on. And don't tell us lesser included. Don't worry about lesser included. Just 1, 2, or 3. That's it. There's no deliberation that's required. But that is her opinion about the matter. So that is essentially what her opinion is. We've gone through most of the opinion and the important parts. And of course, like I said, that little bit of a sly mention of that federal case, which really has nothing to do with this case, Renico versus Lett, an interesting case, but again, nothing to do with this case, and some of the other problems with her analysis. Now, ultimately, is her decision the right decision? And I can say this confidently, her decision is the right decision. This motion should be denied, but not because of the reasons that she said. She did not follow what's required of manifest necessity. But my understanding of the case law is that because they failed to object, that equaled consent. And yes, they didn't have a lot of opportunity to object, but these are seasoned attorneys. The jury was deliberating for a number of days. They had a number of notes that came out. Very clearly, they're hung. A mistrial is certain to happen. So if you don't want a mistrial, now is your opportunity. Make sure that you object. So they should have objected, and they didn't. Okay, so that's the reason why her opinion denying this motion is correct. It's because of that. It's not because of the manifest necessity. The manifest necessity part, she failed on. She didn't follow the law in Massachusetts. And of course, under Fuentes, she did. But all the other case law in Massachusetts, all the other Supreme Court cases in Massachusetts, she did not follow the law. So she has one case, Fuentes, to rely on, but all the other cases say just the opposite, that she has to consider, give opportunity for counsel to be heard, and give careful consideration to the alternatives. And she didn't do that. So ultimately, it's the right decision, but not because of what she said. I mean, there is one part about what she said when she was talking about the fact that they failed to object. That was correct. That was the correct analysis. Now, the whole part about Tui Rodriguez and means that they consented, that's nonsense, like I explained. But the fact that they didn't object, that is it. So, you know, I'm sorry if you're on the Karen Reed side and you wanted to just walk free and not have to try this case again. And like I said, objectively speaking, all of the evidence, the verdict should have been not guilty. It wasn't. We have the system. The jury came back hung, and it's unfortunate if this is what's happening now. But under the law, even though she should have been found not guilty, objectively, according to my opinion or my review of the facts and the evidence, but this specific motion should be denied. And the reason why it should be denied is because of the fact that they failed to object. That was essentially it. That's really what she started. Should have stopped her analysis, but she wanted to really stick up for herself and try to figure out a way that she can look a little bit better, that she didn't follow really the law in Massachusetts. And that's why she went down some of this analysis, which is kind of faulty. Well, that's it for now. Now you have the full analysis on this opinion. Please, if you haven't, subscribe, like, and we will see you next time.